This is Michael Popok, Legal AF After Dark. On Saturday, during the regular Legal AF show, Ben Meiselas and me, my co-anchor, we started talking about what the heck is going on in Florida in the Mar-a-Lago case now. Seems like every time we're reporting on something and analyzing it on Legal AF, we're criticizing Judge Aileen Cannon. Usually for good reason. Now she's making a mockery on how to handle hearings, how they should progress, and she's getting angry for no reason at the government lawyers, at the prosecutors, and starting to yell at them and then taking her gavel and going home when she doesn't like the results. It makes no sense unless she's trying to drag her feet and help Donald Trump as a result. There's a trial she already set for May of 2024 on this case. It's 7 months away. Plenty of time to try Mar-a-Lago twice. This is not a complicated case. As we just talked about on this weekend's edition of Legal AF, take a listen to Ben and me.
Welcome back to Legal AF. We are live, Ben Meiselas and Michael Popok. So we go from a fairly organized docket in the federal case in Washington, D.C., to kind of utter chaos in the docket in the Southern District of Florida in the case involving Donald Trump's willful retention of national defense information and other classified records and top secret records. He's also being charged with making false statements and obstruction of justice. He's got two co-defendants as well, Waltine Nauta and Carlos de Oliveira. That case in the Southern District of Florida, being prosecuted by Special Counsel Jack Smith, is before Judge Aileen Cannon. Remember how we were talking about SEPA Section 4 as it relates to Judge Tanya Chutkan, and how Judge Chutkan is creating a very kind of expedited but very just normal way of handling SEPA Section 4 issues, and Donald Trump's lawyers, as a result, have to respond as lawyers do. They have to basically say, Judge, please, can we be a part of the SEPA Section 4 process? And they're making the appropriate, they're making the requests. They're acting inappropriately, but they're making requests to the judge. The judge can evaluate their requests and their conduct and ultimately make a determination on the merits based on evidence. But then you go to the Southern District of Florida before Judge Cannon. We reported how, again, it's a fairly straightforward case. And as you mentioned at the outset before Judge Cannon, did Trump steal the records? Were they national defense information? Right? It's kind of like that. And did he have the requisite intent? Did he have the requisite mens rea? Almost what the documents themselves say is kind of irrelevant, right? Because the issue is just, were they national defense information? Did he steal it? Did he obstruct justice? Did he make false statements? So actually, the content of the document itself in the DC case is probably more relevant than that in the Southern District of Florida case, even though the Southern District of Florida case involves classified information. But last week, Judge Cannon on her own, basically Trump requested it, but she didn't make a ruling. She basically said that for purposes of SEPA Section 4, rather than even have a SEPA Section 4 hearing or even deal with the documents, she extended the SEPA Section 4 deadline indefinitely. There is no date. She just ordered that those dates be continued. And as she put it, temporarily stayed. So she stayed herself. Oftentimes we hear about the Court of Appeals or the Supreme Court issuing a stay. She issued a stay on herself, right? That was 2 weeks ago. And as we reported, if you go back to the last weekend's Legal AF, we were like, okay, she's doing that so that she doesn't have to issue a final order on the issue that then Jack Smith can appeal. Because Jack Smith has to wait for there to be an order, and then he appeals an order. But when she stays herself and delays the deadlines, trial's supposed to be set in May of 2024. She hasn't moved that date yet. She's doing enough to create confusion without issuing an order that Jack Smith can take the order that you can then go to the 11th Circuit Court of Appeals to get her reversed. And so she's, my view that I said last week, and I think Popok, you agreed, is that she seems to have been doing that on purpose to try to incrementally move the chains or keep the chains where they are, if you will, and just cause delay. And so this week there was a big hearing over the potential conflicts of interest of the lawyers that Trump is paying for co-defendants. His co-defendants, Waltine Nauta, the valet, his co-defendant, Carlos de Oliveira, represented by lawyers named Stanley Woodward and John Irving, respectively. And those individuals also represented, keyword is represented, no longer represent, a bunch of witnesses who want to testify against their clients right now. So that creates a bunch of potential conflicts. And one of the grounds that a litigant can make after they're convicted to try to appeal their conviction is ineffective assistance of counsel. And ineffective assistance of counsel is a ground that cases get reversed on all the time under constitutional grounds in criminal cases, not really civil cases, but in criminal cases. My lawyer was ineffective. So to protect against that, lawyers, prosecutors hold what's called Garcia hearings, where there's conflicts of interests, where a conflict of interest could be used after a conviction by a criminal defendant to basically say, I didn't have effective assistance of counsel. So the question becomes, is the criminal defendant aware of potential conflicts of interest? Do they knowingly waive the conflicts of interest after knowing all of the potential issues regarding the conflict of interest? And is it even a waivable conflict of interest in the first place? There are some conflicts that our law and ethics of being a lawyer hold are so deeply rooted conflicts that they're unwaivable conflicts of interest, and a lawyer has to be disqualified. And what you do is you hold a hearing called a Garcia hearing. It's based on a seminal case involving someone named Garcia. That's why it's called a Garcia hearing. You ask the questions of the criminal defendant in an adversarial way. The prosecutors ask questions. Then the lawyers representing the criminal defendant can ask the questions to try to rehabilitate them or show that there's no conflict. And then the judge ultimately makes a decision, but there's a hearing. So with these lawyers right here who are representing Trump's co-defendants, you'd ask them questions like, one, hey, are you aware that Trump's political action committee is paying for your legal fees? And they may say no. Imagine if they said no, and they go, so you haven't been informed who's paying for your lawyers, and you could explore that avenue. Or maybe they say yes, they are aware. Are you aware that that could potentially create a situation where, because they're getting paid by Donald Trump's political action committee, their loyalty may be split and they may be wanting to help Donald Trump? They can answer that question. Are you aware that you have the right to have a federal public defender? Are you aware that you don't have to be forced to be represented by those people? Are you aware that the government may be interested in entering into plea negotiations and discussions with you? Are you aware that your lawyers are also representing other witnesses who may have testimony against you? Are you okay with that? Are you aware that your lawyer may not be permitted to do certain portions of this case because there may be conflicts presenting that, and you may not have the full counsel, the full attention of your counsel to your case? Are you go through the questions, and then you determine, is this an unwaivable conflict that the lawyer should be disqualified? Should the lawyer just be walled off from certain portions of the case, like cross-examining a former client who's a witness, because obviously they may have learned client confidences in that situation? So can you wall off the lawyer from that portion of the case? Is there no conflict at all, and we could just go along with the case? But once a decision is made after the Garcia hearing, a ruling is issued by the judge. And if the ruling is the wrong ruling, that's where Jack Smith or whoever the prosecutor is can go to the 11th Circuit Court of Appeal. So that hearing was on Thursday. Carlos de Oliveira had his first hearing, and that went fine. But then it went to the next co-defendant, Waltine Nauta, and Judge Cannon was asking questions of the prosecutors, and the prosecutors were saying, well, one of the things we're going to ask for, Judge, potentially, is to bar Waltine Nauta's lawyer, Stanley Woodward is the name of the lawyer again, from potentially being in the case if that's where the evidence leads. We want a full bar, or bar him from being involved in certain portions of the case.
Which, by the way, Ben, came up in the earlier hearing with de Oliveira. One follows the other. That issue was addressed and easily dispatched by the judge with de Oliveira. And then it came up again with Nauta. Go ahead.
Well, because that's what a Garcia hearing is. So when Judge Cannon then got livid at the prosecutors, and she said, you're springing on this for the first time, I feel sandbagged right now, Jack Smith's team of lawyers. For the very first time, you're telling me that you want to potentially bar Stanley Woodward. What's the precedent? Cite me the case. Right.
They had just discussed it 2 hours earlier in the deal. They made a decision, and both parties agreed in front of this same judge just 2 hours earlier that Irving would not be able to cross-examine or handle some part, and that the local counsel in Florida would instead handle that part. And that's fine. Everybody went to lunch. They came back. This judge looked like she had a lobotomy and had forgotten and this is the exact same issue. We don't want Stan Woodward to cross-examine this particular witness. Let somebody else do it. And now the judge is throwing the temper tantrum that you're describing.
And the whole point of the Garcia hearing, right, Popok, is you go through the hearing. What if there wasn't a conflict at all? Or what if the conflict was egregious? Whatever the outcome is, you do the hearing, you go through the questions that I just shared, and other questions like that. And then you decide what the remedy is. She got angry at the remedy that was addressed earlier in the day before doing the hearing. So she yelled at the prosecutors and kicked everybody out of the courtroom and then said, we're postponing this, and that she was just angry. And then that ended the hearing. That's very bizarre behavior. And I want to get your thoughts on it. Yeah. It's not appropriate judicial temperament at all. And, it's what we've come to expect of Judge Cannon. But it's like, even if you had a basis to be upset at the prosecutor, which you shouldn't here, go through the hearing, get the data, and then you could do whatever it is that you want afterwards.
Right. You don't take your gavel and go home, which is what she effectively did. Let me do it backwards. Let me go back to the first part that you started talking about, because it looks like the prosecutors have even narrowed the case even more in the Mar-a-Lago case, and I know I did a hot take on it, and Ben, I think you discussed it maybe with the other podcast that you do. So the government had to respond because, once again, for the third time, Donald Trump and his lawyers asked for a delay in the case. They didn't like it earlier. They asked the judge to set the trial of this matter after the election. Just to remind everybody, the government said, how about January? And the judge says, I'm going to do it in May. At the time, we were like, okay, she's gotten the memo that says this guy's got to be tried before voters go to the polls, not after. And we were okay with that. We were like, okay, it's a little bit later, we can live with that. And then Judge Chutkan said, March, I'll take March. And things are falling into place. But ever since that moment, as you said at the top of the podcast, the defense has sensed that they have a friend in an Aileen Cannon, and they keep trying to use her as a bulwark against a Judge Chutkan and against the other cases. And they constantly run to her like she's mommy to get something that they want, which is a delay in another case. They know Judge Chutkan is an immovable object, but they don't have a rock on the other side. They have Judge Chutkan, who's like a beanbag chair. And so they keep running to her to ask her for something. Help us. And she, she doesn't come right out and say it, but she acts out in certain ways to just naturally, her natural instinct is to delay decision-making, delay briefing, delay, fundamental rulings that she needs to make to keep this case on track. And we know she's doing that because we see her 180% polar opposite in Judge Chutkan, a more seasoned and experienced judge who really isn't letting politics interfere or the Federalist Society interfere with her decision-making, and is making decisions quickly with briefing schedules that are quick, and then ultimate decisions that are there, and keep the case on track for her March date. So when the Jack Smith's team caught that in a reply brief submission, you did a nice hot take on this one, Donald Trump threw in another footnote request for a continuance. We can't try this case, due process. And it's obvious that the prosecutors, hell or high water, even running roughshod over our due process rights, just want a trial before the election, to which, by the way, we say on this podcast, yes, the voters need to know whether they're voting for a convicted felon or not. It's that important. That's more important than a slight delay here or there. And I reminded people on my own hot take There's 7 months from now until March. There's enough time to try 2 Mar-a-Lago cases. This is not a complicated case with a lot of moving parts at all. It's a handful of classified documents. There's 30 in number. Yes, there's a batch of National Defense Information documents, but even the Jack Smith team conceded that the heart of their case, the centerpiece of their case, is not even the National Defense Information to figure out what is or what isn't. It's the 30 classified documents. And I know that because they put it in their own filing, which they just filed 5 days ago. And they said as follows, and I quote from their brief, that the classified materials at issue in this case were taken from the White House and retained at Mar-a-Lago is not in dispute. What is in dispute is that it occurred, why it occurred, and what Trump knew and what Trump intended in retaining them. All issues the government will prove at trial with unclassified evidence. Whether the highly classified documents Trump retained at Mar-a-Lago contained NDI, National Defense Information, is a fact Trump can try to dispute, but it will hardly be the centerpiece of the trial. Centerpiece of the trial is the 30 classified documents. He's gotten 21 of them. There's 9 more to go, which he's complaining about, which is awaiting the construction of this facility and some other protocols to be set in place by a foot-dragging Judge Chutkan, and he'll get those with plenty of time left on the clock. Got 7 months. I've been in cases where the government handed me new information the day of for a witness that was on the stand. It happens in federal court. It happens all the time. So there is no appropriate thing here for delay. And then you have all of that. And then we're trying to explain, being practitioners and being in federal courthouses regularly, what we're observing with Judge Cannon. Now, I'm not here to say that I've never been on the receiving end of an annoyed, irritated judge or magistrate. And neither are you, Ben, or Karen. We have. They wake up on the wrong side of the bed. I used to have a judge who will remain nameless in New York who started every hearing, and not just mine, he starts every hearing with, I hate this case. This case has been here too long. I'd rather not. That's how he started every hearing. And I knew he liked me because we had other interactions. So it wasn't me, but that's how he started. Judge Beryl Howell tore into the lawyers for Twitter when she sensed that they were trying to bend over backwards for Elon Musk to protect Donald Trump. I mean, ripped into them right away. But you also knew her order was going to rip into them. Cannon, I don't get it. I get she's never held a Garcia hearing before. She's only had like 6 trials or 8 trials, and most of them were during COVID. And this issue, these complexities of these issues, she hasn't addressed. Neither now or when she was at assistant Department of Justice attorney, primarily on the appeal side. She never handled them there either. And you don't handle these things in drug cases, which is primarily what's coming through Southern District of Florida. Political corruption cases, espionage, and national defense information, trust me, is not in the judicial training academy for any place, let alone in Southern Florida. So I get it. She doesn't really know, and her staff probably doesn't know how to prep her either. She can make some phone calls to the chief judge. That probably would help. But when you have a hearing earlier in the morning, where the very issue that is now pissing you off and you're throwing the book at the prosecutors for no reason comes up and gets easily resolved, okay, that guy's not going to cross-examine that former witness. We're going to use another lawyer. Good day. And I'm sure the prosecutors were looking at each other, like Tom Wyndham, who got the brunt of Judge Cannon's attacks or reprobation, probably sat at a break with his fellow. What happened there? It's the exact same thing we just did earlier with De Oliveira. What's the problem with Stan Woodward not cross-examining at the end of the day, if it's possible, Walt Nauta? We really don't get all of, or in this case, Yuscil Taveras, the IT director, who's now going to testify that he was in on the conspiracy to try to delete the server footage at the behest of Donald Trump. And he said the exact opposite of that when he was represented by Stan Woodward in front of the DC grand jury. So that I don't get why that issue triggered her so much. Now, I'm still a cockeyed optimist that despite their constant requests, that there's plenty of time left on the clock to try 2 Mar-a-Lago cases, and that we're not going to see any real movement from the trial date that's now scheduled in May, remembering that Judge Chutkan was like, I don't know what she's doing with her courtroom. I'm taking March. And they point to that too. Oh, there's an overlap, and they know it. Chris Keiss, he won't be able to do 2 trials at one time. They're back to back. I've been in back-to-back trials, by the way, and you just do it and you prepare. So we're going to have to, as we've always done, keep a very close eye and try to interpret what we're watching with Judge Cannon. But there's no other way to interpret it, which is an inexperienced judge who seems to be bending over backwards for the defense, and the defense knows it.
Inexperienced, I believe, corrupt, and lacking the judicial temperament to even intelligibly conceal, in my opinion, the corruption that's taking place and the lashing out. It's so obvious what's going on, and it's very just, it's embarrassing for our judicial system to have a judge like this. I'll leave it at that.
All right, that's it. If this is your first time learning about Legal AF, welcome. I'm one of the co-anchors and co-founders. We do stories just like that in a longer podcast, last about an hour, and we cover 4 or 5 major stories at the intersection of law, politics, and justice in the United States that we think, based on our experience, you need to know about. And we do it just like you just saw on that particular clip. If you've already watched Legal AF and you're a fan, you just got to see a little bit longer of an excerpt from our most recent show. MeidasTouch Network, really important in these times. It is not funded by outside investors or ownership. It's not owned by big media. It's owned ultimately by you and your involvement and your grassroots efforts. The bigger this network gets because of your free subscription and otherwise, the more your voice is heard. So if you want to help out, watch us on YouTube, on hot takes like this one, on the Legal AF full-time podcast on Wednesdays and Saturdays at 8 p.m. Eastern Time, only on the MeidasTouch Network. And then you can also follow all of the contributors on the MeidasTouch Network and help them. Leave a thumbs up for this particular video. Helps with the ratings and the algorithms. Until my next hot take, until my next Legal AF episode, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.